problems.
All right, Ben Cusack here from Bulletpoint, and I'm here with Gareth Benson from IP Assist. So I work a lot in the startup space, and I have a lot of clients that might be worth for them speaking to you. And I understand you work a lot within the IP area. What point should my clients come to you?
Look, it's a great question, and thanks so much, Ben, for the call today. Look, basically, we're a boutique intellectual property and commercial law practice, and what we do is we assist, IP assists, navigate avenues towards growth with respect to people's ideas and businesses' ideas. So we spend a lot of time in educating our clients as to the right time in which to protect their intellectual property. We believe that often starts with just understanding what the core intellectual property of their business is. That differs for all businesses, but generally speaking, it's businesses that have been in operation for 2 to 3 years that are on a pathway to growth. The reason being is while that some people might be in business with a great killer idea, which they want to maximize, the reality is that it takes 2 or 3 years before people start seeing a return and have actually built that valuable intellectual property. So in a similar way to you, Ben, it's where businesses are maturing or matured and they are looking at basically investing a lot more into a certain product or a brand. And they need to do further, they want to protect that in order to leverage the valuable commercial benefit. So generally speaking, we're speaking to businesses that are 2 to 3 years in operation on a pathway to growth.
So when I first started my business, which was around 10 years ago, I was very poor and navigating myself. And I thought, trademark. So I went and got some assistance to register the name of the businesses. That's sort of the best process to go.
Yeah, absolutely, Ben. It's the great place to start because most people are under the misapprehension that if they've got a business name registration or even the domain, that actually protects them and protects their brand in the marketplace. It doesn't. Basically, a business name registration is generally just so nobody can have the same name. It doesn't give you ownership of that name. And a domain registration is essentially just a license from GoDaddy or Crazy Domains or elsewhere that you've licensed for a period of time. Only a trademark that is protected under Trademarks Act 1995 will give you the full legal right of use of that name, including the logo and any taglines, colors and shapes, ornamentation. All of these things can be protected under the Trademarks Act. And like we just mentioned before, normally when you're out 2 to 3 years, that's when it's worthwhile protecting because you've developed a valuable brand and reputation in your industry.
So what would happen in the scenario? So in years 2, I haven't registered my trademark, but I'm using it, and someone else comes in and starts using the same, name for their business. What would happen in that scenario?
Great question, Ben. And that's often when I speak to clients is like somebody is leveraging off my name. What can I do? If you haven't had it registered as a trademark, there's still options available to you. You need to demonstrate that you have prior use of that brand and name. Second of all, you better hope that they haven't registered it, even if they've registered it after you, because only a trademark will give you full legal protection. However, you can demonstrate that you have prior use of that name in the marketplace. But again, only a trademark registration will give you official certificate and registration as a priority date on the trademarks register to demonstrate that you have full ownership of that name. The things you can do is that someone does is that you can make contact with them. And if they're not compliant, that's really when you can get someone like IP Assist involved. We have more often than not, I'll give you one example just because it adds some color. I have a client who basically operated a small cafe. It was called The Corner Store, and it still exists in Cheltenham, a very popular place. Down the road, another operator put in Kin Corner Store or started operation. We very quickly swept up the name Corner Store, which we were actually able to register, which is also was an incredible feat to get that through, only because it's generally speaking, it's difficult to own a trademark for common names. However, in this case, we applied for the trademark and we served a cease and desist notice on the competitor to actually notify them that the lodgement had been made, that they had a prior use for 7 years of use in the marketplace, and furthermore, other avenues available to them was that potentially the Kin Corner Store was misappropriating it, known as passing off at common law, and indeed that the actions could thirdly constitute misleading and deceptive conduct, which is the ACCC regulates under the Australian Consumer Legislation 2010. So there's actually 3 avenues to answer that question, but only a trademark gives you the full legal right and is the strongest avenue in ensuring that no competitors use your name, domain names, or any other, even social media. No association can be used, and you have the ability, once registered, to enforce your rights under that act.
I had a similar situation. So when I first started my business, I had a name, and it was actually so it was similar to someone else's, and I got published in the media using that name, and then it turns out that the person that had also been using that name, they went and registered the trademark, and then I've obviously continued to use that name, and then I got a legal letter from them that says, "Hey, you're using our trademark. Stop using it." And then I was doing some research and I found out that, hey, I had prior use, so I could still use it even though they had a trademark.
That's a great example of why you should trademark early. Because what a competitor can do, as happened with you, Ben, is that they went and registered the trademark. Now, you were able to get around it because you were able to demonstrate prior use. And I believe actually that where it's settled, have you registered that trademark, Bulletpoint, in the end?
I have. So I'll tell you a story about that one. So I registered Bulletpoint, just the name. And then a few years later, I see, just Googling, I see so mine's called Bulletpoint. And then I see a website turns up called Bulletpoints with an S on it. And they're in, not the same area, but sort of giving continuing professional development, an online platform for delivering information. I thought, well, hang on, they're using my name. So I went, well, similar. And I went and Googled bullet points into the trademark. What's that place called where you get check your trademarks?
IP Australia that actually does the registrations. You would have checked in at the Atmos database, which is their trademark database.
Yeah. So I saw that they had no trademark. So I went and emailed them and said basically what the F is going on. And they emailed me back saying, "Oh yeah, we've had a lot of people coming through to us looking for bullet point and government grants." I'm like, duh. So once I had discovered that, what should I do that someone's using my name? Is there anything I should know about that?
Well, so this is a good point where you can get us involved. I mean, we often do complimentary searches on behalf of clients just to see exactly where it sits. Until you know, 1, who it is, 2, how they're using it, 3, where whether you have a registered trademark or not, will actually outline, the best strategy there. But in your case, you kind of then recognize it. That's often what we see. We see that people that find out someone's using their name, then they realize that it's the first they know and learn about what the power and importance of trademark and brand protection, particularly as a trademark. The answer to that is you wouldn't drive a car without your car a license. So you shouldn't be driving your business without protecting your most visible asset, which is your brand. I believe at the earliest stages possible, you should think about the trademark registration because it's not only protecting your name in the marketplace off competitors, it's also about protecting the valuable marketing that you've done over years, including your website, your business cards, your logo, the money you've spent with, a graphic designer, and all those things are really, really important. The one tip that I can give here, Ben, is that for anyone that is out in business, they should utilize the ability to use a TM next to their brand, particularly as it provides a ring fence around your brand. It actually, legally, you can use that as it notifies an intention to trademark. Only when it is a registered trademark may you move to the R symbol. However, most people can, would be wise to use that in their logo and branding because it notifies an intention to trademark, and that will be can be very valuable. Basically, Ben, I see the protection of intellectual property a little bit like that. It's a ring fence that goes around. If you leave your door wide open overnight, for example, how long do you think it would be if someone came to collect your plasma screen, TV? It's the same as true in business. If you leave the front door open, leave your intellectual property, your brand name, your even your ideas around, you're inviting people to take them. So you should take preventative steps, put the ring fence around it, and ensure with safety that you can go out to business knowing that you've protected your important. And it just begins with your brand. There's many other things as well that we help protect, but your brand is the most obvious one because for all of us, our brand has substantial worth. It's our identity, and your identity is worth protecting.
So I might be a good case in things of what not to do. So one, I using someone else's trademark in the past. Two, I didn't, someone else copied my trademark. And then the third one, so I registered the name. I didn't register the likeness of the logo. So it turns out someone started using a logo that looked very much like mine. And it's quite a well-known brand. So if you look at the Bulletpoint logo, and then you go and look at the Finder.com logo, and you might be able to overlay this and show other people what it looks like. So the Finder.com logo is a well-known sort of comparison website. Same colors, same little dot before the start of the word. I'm like, that's mine. But then I realized I don't have a trademark on the look and feel of the logo. So tell me, what should I do? What should I have done, or is it too late to do anything now?
Look, definitely. If you haven't done the logo, then I would do that. There's a couple of points. The first is you get the bullet point, which is you get the name. That is very strong, actually. If you're the first to market, I should just add at this point that there are 42 different goods and service categories that can be registered under, which are particular to your industry. So for example, Ben, I would assume that you'd probably be in a class 35 because you're in a consultancy area as a business consultant, but you might also wish to also extend that into other services. For example, there might be one under, or I know class 41, for example, is education and workshops, training and education. So you need to have a forward-thinking approach to where your business is likely to grow in 10 years to make sure that you have covered it in the important products and service categories, a trademark registration stage. The first step then is to get the name. If you're the first to an area of industry and you get the name, that's very, very strong. But as your business grows, you want to make sure that you're also protecting your logo. For example, Cadbury has there's a purple behind me here. Cadbury have trademarked a particular shade of that really dark royal Cadbury's chocolate, right? And in the UK, there's been litigation on the use of that. So you can protect the name, but it's also a badge of origin. It's the combination of elements that make up your distinctive brand. So it can go to color, it can go to style, it can go to the logo that your graphic designer has created. And both are worthy of protection. The answer to the question is, Ben, you should not only have the name, because it's actually very, very strong to have the entire name, but you should ensure that you have a separate trademark for the logo as well.
That would have been good for me to have known 10 years ago.
Sure.
But that's, I'm sure not the first person to find out that issue.
Sure. Well, that's why we spend a lot of time doing education with businesses of all sizes and shapes, because we believe, unlike other Collins Street lawyers where they'll charge by the 6-minute increment, we like to give our education up front. We like speaking about people's ideas, and we like empowering people to know where the value of their ideas lie. Trademarks is just one of those areas, and it's the easiest one to grasp when you're coming out into business, because everyone's got a valuable brand that they're developing, and it's worthy of your protection.
Now, probably one last final thing that is more for, not just for me, but for my client side. So I work with a lot of companies in the startup space, and they have ideas and they have processes and products. What point should they come to you in that process, in the development process, in order to protect what they have or what they're going to produce?
We've got a number of videos that we've produced, with, for example, Silicon Beach, Melbourne, which actually gives an indication of one of our workshops where we happily talk people through the valuable IP, which exists as copyright, could be trademarks, there could be patentable ideas, or designs. It depends on the nature of the business. The answer to that question is that we're always happy to chat with people, about their idea and to actually give them the fundamentals of what they should be considering. But generally speaking, it's when they're in a pathway of growth or they're going for investment funding. Because on the other side of the R&D grant, there is also other investment avenues available to people with ideas. But one of the first things that an investor, well, not the first, but one of the things an investor will ask you is, have you protected your intellectual property? Why? Because at the end of the day, when you've got very little tangible assets, the investment is going to go into intellectual property. So it's important that you've considered, at the very least considered, how you're going to actually protect it or value it, so that they know that they're not going to lose the valuable investment in your idea. So the answer is to that, Ben, is basically we're happy to talk to people at any stage. However, when you're preparing for fundraising, it becomes really, really important, because you want to make sure that you've got a vehicle to actually accept the investment. And that often means the intellectual property should be tied more often than not to a proprietary limited company, which will issue shares in return for the investment that an investor funds your business. It's what they're investing in, the intellectual property.
Okay, so how long would that process take? So I come to you and I want to get some investment on board. How long do I need to sort of have a runway or delay that process?
Well, I think that if you're speaking to investors, you should have that conversation now. If you're preparing for investment, you should spend 2 to 3 months beforehand just understanding everything you need in order to get your house in order, so to speak. It might be an existing business or it might be totally new. But an example last year is that we had a client that was developing an app in the influencer space, and it was a brand new idea. And the person came from a strong branding and marketing background, but they were creating an app. And so with that, even though the app was still in development, they took a provisional patent over the idea. And we do have a specialist that deals specifically with patents. He's actually an entrepreneur, much like myself, and where we develop businesses ourselves, but he's registered software as patents before. So he took care of the provisional patent, and then I took care of setting up the business as a proprietary limited company, both as a holding company and as a trading company. And then we made sure that the provisional patent was assigned to the holding company as an asset, which then allowed them to go and continue their investor discussions, knowing that they would be that if and when they secured funding, they basically would go into basically the holding company as shares, and that they could actually trade without threatening or putting their intellectual property at risk. So that's just one example of a client that was preparing to fundraise, and we made sure that everything was set up so then they could talk to their wealthy network of international investors, and knew that they could also they could be checked out online through ASIC. That's one other way that investors will know you're really serious if you have put the proper commercial thought into how you've set up your business, including in how you've treated your intellectual property, or at least plan to treat your intellectual property once funding is secured.
Can you tell me, you mentioned there's a trading entity and a holding entity. What would happen if I put my assets in my trading entity, or just had one company that I did everything out of?
Well, it's like this, you kind of, I see the vehicles in which you protect your assets much like castles. You have a castle, which is your holding company. This is where you have a moat, you have a high walls, you have a proprietary limited company, and you put your valuable treasure, your idea, in the castle. The trading company is the horse and cart that goes out and distributes the vital product or service. But they're separate, because for whatever reason, should now or in the future there be any difficulty, you don't want to keep your assets too close to the to the coalface, so to speak. You want to make sure that they're separate, because it offers you an additional layer of protection. And the reason I say that, not that it has happened all that often under my watch, however, if for whatever reason you're sued, while you're out there in the course of business, for whatever reason, then basically with a trading company, if there's a problem, you can just tie it up, and it's not the ideal situation, but you can, and then the asset stays secure. It's much like sometimes, it's an avenue or a strategy in protecting not only yourself, but also your intellectual property. And these are the kinds of strategic decisions we help mature business owners make, particularly at various stages of the life cycle of the development of a startup or a business. You're going to have to get specialized legal advice into how to actually fully protect yourself. And of course, your most vital asset, which is your ideas, or and the products and services that lie underneath those ideas as well, which could at that stage be highly developed registered software, or it could be manufactured designs, or there are a number of other pieces of intellectual property that fit within a business. But much of that starts with understanding what it is, so then you can develop a strategy, which is what we help people do around their intellectual property.
So tell me, so obviously my assets, my IP is sitting in my holding company. How does the trading entity use the logo or whatever IP? Do they need to do anything in between those two companies?
Yeah, they need to speak to each other. So basically, often or not, there'll be a license agreement for a specific period of time for one company to use the others that license the IP. So it's a license is essentially a contract, commercial document that licenses, the intellectual property for a specific purpose. Now that could be another customer, or another operator in the industry, for example, or it could be your trading company. Because then, for whatever reason, there'd be a termination clause within the license, which basically severs the relationship between the two. Know that a company is essentially a separate legal personality. So they operate, they operate separately, and therefore, you do need a document that speaks between the two. Much like also when you're setting up a business, with either of those situations, you would more than likely have a partnership agreement if there was more than two of you, or more than one of you, sorry, which actually dictates the contribution and the way that that you handle the business, accounting, everything from accounting decisions through to how the intellectual property is treated. So, by the time you've got a mature business, you've got actually a relationship between a couple of entities and contracts in their place, just to ensure that you've got a secure vehicle to go out and do business with.
That's great. That's given me some very good insight. I appreciate your time, Gareth, on that. And look forward to talking to you again. I'd love to know more about patents, but happy to talk to you next time more about that one.
Sure. Yeah, I'd be delighted to. I think there's a great overlap in building a bridge between the funding required and what businesses need to know. And I think both of us are happy to assist. By the way, you can check us out on ipassist.com.au. There's a number of, we're actually going to be uploading more resources to that page to help people, like this video, for example, on how people can navigate towards their most important asset, which is the value of their ideas.
Thanks a lot, Gareth.
No problems, Ben.
That was another good one.
That was a meaty one. All right. That's enough over